Hey folks, welcome back to the channel. Today we've got a case that's as brutal as it gets. The defendant stands accused of breaking into his ex-girlfriend's home and brutally assaulting her and her new boyfriend. His attorney argues for a bond, but with the severity of this case and a history of violent offenses, it's unlikely things will turn out in his favor. The judge has some tough decisions to make. Let's see how it all unfolds.
Full name. Darius Carter.
I'm ready. I'm Darius Carter.
All right, good morning, council.
Good morning. May it please the Honorable Court.
Calling case number 240-585-6001, people of the state of Michigan versus Darius Carter. For the people.
Thank you, Magistrate. Good morning. Steve Vincent, P71917.
Thank you.
And good morning, Your Honor, to your staff. May it please the most Honorable Court, Mohammed Nasser, P74485, appearing on behalf of Darius Carter, who appears via the Detroit Detention Center. Please state your name for the record. Mr. Carter, your name for the record.
Darius Carter.
Thank you. For arraignment purposes, Judge, the defendant will waive the formal reading, stand mute, come to request the court to enter a not guilty plea on his behalf.
Thank you. Court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I'm going to take about 5 minutes to look at this investigator's report. Feel free to have a seat if you wish to do so. I'll let you know as soon as I'm ready.
Thank you, Judge.
Thank you.
And I apologize. Would it be possible for me to take a look at it myself? Or,
Sure.
Thank you. Thank you so much, Judge.
You are welcome. Okay. Arguments as to bond, first from the people.
Thank you, Magistrate. And I got to start off by saying, notwithstanding the fact that the defendant ended up retaining very good counsel, who's before you in the courtroom, the people feel as though there's no better candidate for remand than the defendant before us this morning. Based on the substantial criminal history of this defendant, where I counted eight prior felony convictions, based on the assaultive nature of some of those convictions, including assault with intent to do great bodily harm less than murder, as well as felonious assault, based on his HAB status, which is now at a HAB 4th notice, based on the fact that this defendant is currently on probation, was on probation at the time of this offense, and had only been out of jail for less than a month before this offense took place. And then let's base it on the allegations here, which are brutal, they're highly assaultive, and the allegations allegedly were only motivated because one of the complainants didn't call this defendant back, who was an ex-girlfriend of the defendant's. We feel as though remand is appropriate. As Your Honor, as well as defense counsel can see, we have an individual allegedly who ended up breaking into a house, ended up pistol whipping to the point of unconsciousness his ex-girlfriend's present boyfriend, and then ended up assaulting his ex-girlfriend as well. And then he flees. Judge, I believe we have identifications as well of this defendant being the offender. Fortunately, we're not here as a direct result of somebody dying, even though it appears it was very close, based on the loss of blood, based on the blood puddles that the police ended up observing at the house that the defendant ended up breaking into and brutalizing these two people. So respectfully, we feel as though remand is appropriate.
Thank you.
Your Honor,
Yes.
Mr.
Yes.
Vincent has spoken very eloquently, so I'll try to keep pace, Judge. Undeniably, the allegations are the allegations. I've had an opportunity to review them as well. As this court is aware, as it relates to bonds, certainly we can rest on what the investigator's report would state. However, there are some mitigating factors here, Judge. This court should be aware, and what Mr. Vincent did indicate is that, one, my client did retain us and we surrendered him ourselves to the Detroit Detention Center. In actuality, I tried to surrender him last week and was unable to do so. I tried to walk him right into the 36th District Court. I spoke to the supervisor who indicated that this is not possible. So predicated upon that, we set up a surrender date, which I would be in the building so I can make the argument. So, Judge, he's not running. An individual that voluntarily surrenders himself to the police does tell this court, one, that he's not a flight risk, and two, that he has the desire to address this particular matter. Undeniably, I would concur with the sentiments of Mr. Vincent that there appears to be identification based upon an ongoing relationship between, my client and one of the complainants. That being said, Judge, I'm asking this court to consider a bond that is reasonable. I don't believe a remand is necessary. There isn't a loss of life. Even the medical report suggests that while there was some notation of temporarily serious, ultimately these people were released from the hospital. So in light of the fact of his ties to the community, the fact that he has retained counsel, and most importantly, Judge, the fact that he surrendered himself. This is not an individual that was arrested at the time of the incident. There's been some time that has lapsed since the date of this incident. And again, he's voluntarily surrendered to address it. I'm asking for a bond that is substantial, but not greater than necessary to ensure that he's going to follow the rules and not have any contact. GPS tether will certainly circumvent any type of contact provisions. You can know exactly where he's at. Certainly, he's not going to go anywhere near the location, the incident location where this took place. He's not going to go anywhere near the complainant or the complainant's boyfriend. So I would ask for a GPS tether. As for bond, Judge, I would ask this court to consider $35,000, 10% GPS tether. If there is a house arrest provision, I would ask this court to consider that the time allow this young man to go to work.
Thank you. All right, Officer Tompkins, would you please just retrieve the investigator's report so I don't forget? Thank you. Okay,
Sorry, Judge.
that's okay. Mr. Carter is charged with two of the most serious crimes that we have, short of homicide. He is alleged to have gone into the home of his ex-girlfriend, knowing she was there with another man, to have forced entry into that home, and then pistol whipped both her and the person who was there, causing severe injuries. The assault upon him alleging to have gone beyond just pistol whipping, but stomping, etc., leading to hospitalization. The identification is made by a person known to him. He was seen arriving at the house with another individual on a neighbor's Ring doorbell camera, placing him there. Obviously, something happened because there are people who suffered injuries and were hospitalized as a result. And while there might be some argument later about mutual combat, here we have him going to the place where she was located with another man, allegedly knowing that that's what was happening. So, counsel, while all of your arguments quell any concern I have about flight risk, he's turning himself in. He's retained extremely competent counsel. I don't believe he's a flight risk. He's wishing to face the charges. The allegations contained here with the Ring doorbell, with the identification by a known individual, combined with the Mr. Carter's HAB 4 status at this point, two of those HABs being things that caused the court concern about community safety. Actually, several of them. I've got a prior GBH, assault with intent to do great bodily harm less than murder. I've got a prior assault with a dangerous weapon. Conviction date the same, telling me that GBH involved a weapon. I then have possession of a firearm and discharge of a firearm in or at a building, and possession or use of a firearm in the commission or attempted commission of a felony, telling me that back in 2006, whatever that GBH involved, it involved the use of a firearm and the firing of a firearm. I have here at least someone who thought they had been shot, who turned out was simply suffering injuries from the assault. but we've got some involvement in allegation of a firearm, because we know the allegations that the firearm was alleged to pistol whip, although it didn't result in a gunshot. Given all of that, I do see Mr. Carter as an extreme danger to the community. And, my concern is that something that has risen to this level, involving going to a house, seeking a person out, forcing your way in, inflicting injuries serious enough for someone to end up hospitalized. Those are the allegations, then coupled with the prior convictions that start to look very similar, cause the court to believe he is a danger to the community. I've said it now, I don't believe in clogging up the redetermination docket when remand is available, and I believe that's what is appropriate. So there is going to be a remand in this case. September 26th is going to be the date for the probable cause conference. October 1st is the date for the preliminary examination. No contact or attempted contact with either of the complainants. No verbal contact, no written contact, no contact through third parties or social media. Any attempted contact would be considered a violation of the conditions of the bond. If he's able to get a bond or get out, there is to be, again, no contact with the address where this is alleged to have occurred, and not to purchase or possess any firearms or other dangerous weapons will also be conditions of the bond. 26th and the 1st are both listed in front of Judge King.
Thank you, Judge. Now, for bond redetermination, would that be done on 9/26, or is that still in court?
There will not be a redetermination because it is a remand.
Okay,
Okay, so next court date is September 26th.
thank you.
The defendant's violent behavior left no room for leniency. It's hard to see how he could have gotten a different outcome, which raises the important questions. What could have been done differently to keep this situation from escalating? And did his behavior leave the judge with no other option? Let me know in the comments. And don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.